Welcome back, and welcome to our presentation on courtroom testimony. Well, as we know from our study of evidence law, there are two forms of testimony. One is a fact witness, otherwise known as a lay testimony or a lay witness, and that testimony is done under Rule 701. As we've discussed numerous times during the course, there's a good possibility that some, if not all, of your testimony will be done under Rule 702, 703, and 705, which cover the testimony by expert witnesses. This testimony not only gives you more rights, but also more responsibilities, and it also is going to force the jury to look at you a lot more critically. And so it's very important that you present yourself well in court. We're going to try to help you do that. One of the things that I need to start with is the notion that what you see in TV is not real law. Anyone that's been in court realizes that it really doesn't look like you see it on Law and Order. And one of the things we'll notice is that they very often don't pay a lot of attention to a lot of the rules and the structure of testimony in court. But whether you're testifying as a lay witness or an expert witness, there is no substitute for preparation. I can tell you my own rule of thumb was that at least a month before trial, I would be starting to get ready. At 2 weeks, I would be doing nothing but trial preparation, and at 1 week, my entire focus was on the testimony at hand. You can't be over-prepared. You can look over-prepared, but you really can't be over-prepared. This seems kind of obvious, but it is surprising how often I would get calls from prosecutors that would say, you know, can you come testify next week? Okay, what is it that I'm going to testify about? What level of detail do I need to go into, given this particular case, given the facts, and given what your theory of the case is? What physical evidence am I going to actually get admitted? And by the way, who's going to admit that? Am I going to admit that? Have I got to be responsible for bringing that to court, or is someone else going to have that already and it is already going to be admitted? How does this evidence, and in particular my testimony, how is that going to fit into my side, or the side that's calling me's theory of the case, and how might it fit into the other side? Realizing that there's always two sides of the story, and as a forensic examiner, you're testifying for the truth, not for either side. So you have to be equally prepared for the issues for both sides. In the real world, the order of testimony goes like this. Whoever calls you gets to examine you, and that's called direct testimony. And if you're testifying for the prosecution, you testify as a prosecution witness. If you're testifying for the defense, you testify for the defense side. Regardless of that, there are some rules about that which we'll go into in a little bit. Once whoever calls you is done examining you on the stand, then the opposing party gets to examine you, and that's called cross-examination. They actually have a different set of rules that they go by. If there are issues that were brought up on cross-examination about the direct testimony, then the person calling you can re-examine you, and that's called redirect. And in turn, the opposing party gets another bite at the apple, and that's called recross. In theory, there is re-redirect and re-recross ad nauseum, but judges don't like that. Judges expect lawyers to do their jobs and get their testimony out the first go-around and in a very efficient manner. And they have very little patience for multiple iterations of testimony by witnesses. If you're being called as an expert witness on your direct testimony, the first thing that will be done is to establish whether you should be admitted as an expert. and it is the judge's determination of whether you qualify. And as we know, that's a Daubert decision in many jurisdictions. But before reaching that Daubert decision, what will typically happen is that they will put you on the stand and they will ask you a series of questions in order to ascertain what your qualifications are to be an expert. Now, first of all, if you're proffered as a 702 witness, under the Federal Rules of Criminal Procedure, the side calling you is required to provide the opposing side with your curriculum vitae prior to trial. So who you are is not only going to be well known to the opposing counsel, but they will probably have done some research on you as well. And so the assumption is everybody really knows who you are. Sometimes attorneys will take shortcuts, and this is one of the issues that you really want to resolve with the party that's calling you. Ask them to ask you a specific set of questions regarding your background. And in fact, I actually give them a qualification sheet that says, please ask me the following questions in the following order. I absolutely despise the notion, and it really is terrible testimony when they get up there and say, well, tell us what your background is. It is very difficult to not sound boastful. It is very difficult to remember exactly all of the things that you want to include in your background and in the correct order and the dates. It is much better to have that elicited in one package at a time. So I recommend that you work that out ahead of time. Occasionally, what will happen is that the opposing party will offer to stipulate to your expertise. What that means is, yes, Your Honor, no problem. We think that this person is an expert. Let's, just get on with it. If your counsel is smart, they will not allow that. They will argue against that, although the judge may overrule. You want the jury to hear what your expertise is. You want the jury to know that you have formal education, that you have all this training, that you have all this experience, because what the jury has to decide is not just what the facts are, but how much weight to put on them. And how much weight they put on the technical testimony in large measure is how much weight they put on you. And so you really want them to hear all that. And then the judge finally makes the ruling on admission. And by the way, the opposing party can cross-examine you on voir dire. If they do, be a little bit careful, because they usually are going to try to elicit something that they're going to use later on in your cross-examination. So answer truthfully, be straightforward, but just have that little buzz in the back of your mind that says, I might hear this one again. And then you go on to the main part of the direct testimony. In a lay witness testimony, it is very pro forma. You ask the person their name and their address and their employment and all those sorts of things. And then you either ask them the who, what, when, where, how, and whys if it is recollection testimony. If it is, if you're going to admit some physical evidence, then it has to be admitted through a witness. And this is where your marking and identification comes in. You may be asked to admit a piece of evidence, and the only way that you can identify that and therefore authenticate it for admission is that you can show the chain of custody and you can identify that piece to the exclusion of all others. You may on occasion be asked to do your testimony and evidence that's been already admitted by somebody else, but in that case you're going to have to identify the evidence as well. When they hand you the hard drive, make sure it's the right hard drive. And you need to discuss all these things in advance so that none of these are a surprise. On direct testimony, there are a number of ways of doing it, which we're going to talk about here in a minute. But one of the things that you cannot do in direct testimony is you cannot lead your own witness. And that's a general rule. There are some exceptions to that, but I'm not going to cover the exceptions in this particular talk. But the questions themselves have to be direct. And what I mean by that is you cannot ask the witness, isn't it true that, or you did do that, didn't you? Those are considered leading questions and are not allowed in direct testimony because you're assumed to know what you know, and the lawyer is assumed to know how to ask the question in order to elicit your testimony. So leading questions are not allowed because it, in effect, makes your testimony the testimony of the person that's examining you. There really are two approaches to doing this, one of which is literally a question and answer, and in some cases it's good to set up your testimony with questions and answers, and in some cases I will actually provide the attorney with a list of questions that I would like as set up questions so that I have everything that I need to do the rest of my testimony. Then the rest of the testimony may be narrative, which basically says, tell us about your examination, and then they sit down. Some of it depends on what the attorney's goals and objectives are, what their experience is, what their trust level is in you. So you need to be, discuss that well in advance with them. But at some point, it almost has to be a narrative testimony. And it's important for you and the prosecutor really to kind of follow this outline, whether you do it with questions and answers or narratives. First of all, set up the situation. You need to have all the facts on the table that you're going to subsequently testify about. You need to know what evidence it is. You need to clarify in the jury's mind what evidence is it that I'm going to be testifying about, and that really is the job of the attorney. And then at that point, they're going to ask, is it possible, or did you do a forensic examination on this? Yes. Okay. And from that point on, you need to kind of follow in with what is the science behind this. Don't get right into the examination, typically. If there is anything that's going to be at all complex and the jury is going to need to kind of digest, one of the luxuries that you have as an expert witness, and really one of the duties you have, is to make sure that everybody's on the same sheet of science paper, if you will. And so you have to educate the jury. This may be where you're going to talk about how does a hard drive work. This may be how you're going to describe how things are deleted, or how internet cache works, or how a spooler file works. Whatever it is, if there's any science that's not intuitively obvious, right, this is the time to set up that science. Then you go back and you describe the examination. Now, in this particular case, I examined the drive, and this is what I found. And remember how we talked about how the spooler file keeps the material that's going to the printer in a temporary file? Well, I found one of those temporary files, and here's where that temporary file was, and here is what the temporary file showed. And this is typically where you're going to admit your trial exhibits. And you need to discuss with the attorney how you're actually going to do that, and where in your testimony that's going to be, so that they have an opportunity to get it admitted, because you're going to have to have them bring it to the court's attention. Once you've described the results and you're certain that everybody understands how you got to that point, then you have to describe your conclusions and your opinions, your basis for them, and how they are demonstrated in the evidence. And to me, this is another opportunity to go back through and say, okay, remember how we said that the computer has a file system, and that file system is stored on the hard drive, and the hard drive keeps some information in there somewhat permanently, and some of it is there temporarily. And remember how we described that when you take a Word document, that when you go to print it, it has to convert it into the format that the printer uses, and that's a spooler file. And here's the spooler file that I found. Here's the content of that spooler file, and that I think that this spooler file was printed out on the defendant's printer, and I believe that because the spooler file is in the format for a Canon, whatever it is. So you have to lay it out, and so I would walk them through it again, just kind of educating them as they go along. That's what expert testimony really is, until you walk them through your conclusions and the basis for those conclusions. Cross-examination. Once you're done with that, then it's the opposing party's time. And they have a different set of rules. They may force you to use yes and no answers, and they can ask leading questions. Now, they can use those, but that doesn't mean that in all cases you have to answer them that way. If they force you to use yes or no questions, and the issue requires more explanation, particularly if it's a technical explanation, then you need to state that a yes or no answer is not sufficient to understand the answer. And if they still insist on you doing that after your complaints and perhaps even the objection of counsel, although they will not always object, and I'll explain that in a little bit. But if they force you in the end to answer yes or no, the jury knows that there's more to that question. And equally important, your counsel knows that there's more to that question, and so they will likely come back and revisit that on redirect. Generally speaking, cross-examination tends to serve one of three purposes for the opposing counsel. And they're all legitimate, and you have to be very neutral about this. This is neutral testimony. You should not be testifying in a different tone or attitude for one side as the other. The truth is the truth, and you're sticking to that. In many cases, there is favorable evidence in the examination for the opposing counsel, and so they will ask to bring that out. And you bring that out in the same professional way that you do the direct testimony, including educating the jury about it. You cannot be partisan about this, and this is a real test for forensic examiners. In some cases, what they want to do is bring out unfavorable evidence. And there again, it's not your case, it's not your prosecution. You need to acknowledge whatever the issues are and deal with them very factually and very scientifically. The third thing that they may try to do, which is dangerous to do if it fails, and it's dangerous for you if they succeed, and that is to impeach you as a witness, or at least reduce your credibility either in terms of the process that you used or in the actual factual part of the testimony, or to your character. And so you have a lot to lose in impeachment. Their problem is that if they fail to impeach you, or if it looks like they're beating a dead horse, then the jury very likely will rebel at that and may very well be on your side. So it's a very tricky thing for them to do, but you need to be aware that if they successfully impeach you, that you've got a real problem, not just in this case, but in future cases. A couple cautions here. Open-ended questions and silence are deadly. One of the oldest tricks that lawyers will use is they will ask a question and they'll sit down and they will not say a word. And people have this tendency to try to fill up silence, and they're hoping that you'll just say one sentence too many or one thing too many, and so you need to be very aware of that. Open-ended questions, you need to figure out not only where to start but where to stop, and when you get to that point, you stop, you shut up, and you wait for the next question. When they ask you a question, you give them the answer and they don't respond right away, they're trying to get you to say more. If it's not the side that called you, you really need to be careful about what you say next. When the question is asked, and very often lawyers will ask these questions in a pattern, in a pace, and they will get you used to answering questions at a particular speed. That can be a very dangerous thing, as you've probably seen on TV, where they say, isn't it true that, isn't it true that, isn't it true that, and then the last question really isn't true, but you answer it in the wrong way. Or you are asked a question that is convoluted, and you don't take the time to dissect what the question actually is. And so here's my little technique for avoiding doing any of the above. So when somebody asks you a question, don't answer it. I don't mean forever, but I mean let there be a little silence. During that silence, make sure you understand that question. Play it back in your head. Is it a double negative? Is it they're asking for one thing and it sounds like something else? Make sure you understand what the real question is. Formulate your best answer. Take a deep breath and then answer it. Address your answer to the jury. You are talking to the jury. You are not talking to the counsel. If the opposing counsel or any counsel can, they will try to make what they want to say come out of your mouth. Don't let that happen. Make sure that the testimony is your answer to the question. If it's the wrong question, that's not your problem. That'll get sorted out in court somewhere down the line. Your job is to answer the questions truthfully, evenly, professionally, and as completely as you can. Thereafter, you can have redirect and recross. The general rule for both of these is that they can't elicit any new testimony. They can revisit testimony that's already in the record, either on direct or cross-examination, but they can't really bring in anything new. It is generally a spin exercise. They're trying to put the right light on your testimony. A good way to help that process along is to reinforce your testimony by saying things like, okay, as I explained before, you do this, you do this, you do that. Make it a repeat learning experience, and my experience is that you won't have to do it very often. As I mentioned before, judges just don't have any patience with extended examinations. They're very jealous of the amount of time in court, and they really beat up on attorneys when they're not moving along quickly enough. So this doesn't usually go on very long. All right, let's talk about courtroom mechanics for a minute. First rule in my mind is, if at all possible, go and look at the courtroom before you have to testify. In some cases, if I have to testify on Monday morning, I'll even go to the courthouse on a Sunday. I'll talk to one of the security folks or one of the marshals and say, look, I'm testifying tomorrow. Is there any chance I could just take a quick look at the courtroom? Things like figuring out how that little gate works can keep you from looking like an idiot. Realize that you are on stage from the minute you're in that courthouse. People are going to look at you. Your dress and your demeanor say a lot about you and prime people for what to expect from you. Make sure you're professional at all times. It's not at all unusual to be in a courthouse, ride up in the elevator with a bunch of anonymous people, only to find out that some of them are going to be jurors in your case. Literally, as you walk into when they call you as a witness, from the second they open the door, you are literally on stage. You need to move professionally, act professionally, and be a professional. And that starts with how you dress. A book I would highly recommend is a book by the name of John Malloy called Dress for Success. It will come across as very sales-oriented, and it is, but Malloy has done a tremendous amount of research in figuring out what people trust and what people don't trust. And there's a reason why FBI agents wear blue suits and white shirts. It's the same reason IBM salesmen wear white shirts. There are some good research that indicates what people trust. They're expecting you to be a professional as an expert witness. You need to dress that way. You need to dress conservatively. Be very, very aware of jewelry, both in terms of things like fraternal pins and things like that, but also in terms of gold jewelry and decorative jewelry. Realize that somebody on the jury may not like whatever the organization whose pin you've got on there is. Someone may be offended by somebody that's wearing too much gold or has too many gems or whatever. Be aware that you need to be kind of toned down and realize that juries may react to things, and in different places they have different reactions. You're going to be inspected when you're on the stand, and one of the things you want to try to avoid is being hard to look at. And I mean that in a very literal sense. If you're wearing really bright colors, it's hard to look at you. If you're wearing patterns that move as you do, it's very hard for the jury to focus on you for extended periods of time. Ladies, if you're wearing revealing clothing, it's going to detract from your testimony as well. It needs to be easy for the jury to focus on you, your head, your face, and your hands as to what you're trying to get across to the jury. So dress appropriately. Plaid suits are probably not a good idea. While you're testifying, as I mentioned before, think before you speak. And the way to do that is to take a breath after the question is finished being asked and before you answer. Speak clearly and distinctly, and you need to do that for a number of reasons. One, very often a lot of the jurors will be on up in age, and so they don't have the best hearing. You want to make sure that the record is clear, whether it's on tape or a court reporter is transcribing it. You want it to be very clear. Slow down. Understand that you're teaching, you're not having a conversation. Address the jury. They're the ones that matter. Make eye contact. Look at the jurors as if you were teaching a class and make sure they're getting what you're saying. And if they're not getting it, find another way to say it and keep plugging away until you see this level of understanding in the jury. Keep an even pace with both testimonies. Direct and cross should sound absolutely alike to the jury. Keep an even pace. Be direct and truthful, even if it doesn't feel good. You cannot appear to be partisan. Make sure that you clearly differentiate fact from an opinion. And when you make a conclusion, that is a fact. When you make an opinion, that's exactly what it is. It is an opinion. Prepared exhibits. We're going to have a separate presentation on this. But it's often important to explain complex topics. So you need to develop professional exhibits that will help you illustrate your explanation. That's particularly true if you're not much of an artist, which most of us aren't. The exhibits themselves may end up being taken into the jury room to assist the jury. And so you want these things to be self-explanatory. And to imprint, if you will, on the jury. Very often courts have restrictions on the sizes of exhibits, and so you need to find that out ahead of time. And some courts even require you to obtain the court's permission before using trial exhibits. Nonverbal communications are probably as important as your verbal communications in testimony. A perfectly good factual testimony can be ruined by nonverbal communications which indicate that the speaker is not comfortable with what they're saying and how they're doing it, or that they're sending conflicting messages that while they're saying this is how it is, their head shaking, it's giving you an indication that maybe all is not well. The nonverbals, particularly on cross-examination, are very, very strong indications of whether the jury is going to believe you or not. Unfortunately, a lot of us have nervous tics and body postures. We need to be very aware of those. The best way to do that is to have somebody videotape you as you're practicing your testimony, and that, by the way, is perfectly acceptable. And the one thing that is as much a nonverbal as it is a verbal thing is showing respect for the process, for the court, for the attorneys, and most of all for the jury. How you address them, how you sit, how you look. Realize that these are important people that are doing an important job, and that your behavior should show that you respect them. When you're done with your testimony, get up, don't yell, don't shout, don't clap. Get up, leave professionally. Don't be high-fiving the attorneys or saying hi to your friends on the way out. Right? Walk out of there and get the heck out of the courtroom. In fact, if you can, get the heck out of the courthouse. I will tell you a personal horror story of mine. I finished an expert testimony. The case agent was an old protege of mine. I had previously agreed with her that I would meet her for lunch. My testimony, I thought, was going to be the last one before lunch. And so when I got done, I left the courtroom and I waited out in the lobby of the courthouse. Well, unfortunately, the lawyers decided to argue some motions, so they dismissed the jury, and the jury came out into the lobby. Seeing me standing there, several of the jurors approached me and started to talk to me. That is grounds enough for a mistrial. And so I, as tactfully as I could, said that I'm sorry, I appreciate your attention, but I cannot talk to you without a risk of a mistrial. They understood and went on their way. But the moral of that story is get the heck out of Dodge if you can. Okay, well, this has been a real quick session, and if you have any questions, I'll be happy to answer them when we meet in person or via email. Until next time, have a good day.